This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we were talking with Adam White about the administrative state under the Trump administration. Adam White is a senior fellow at the Hoover Institution. He's the director of the C. Boyden Grade Center for the Study of the Administrative State at George Mason, or I should say the Scalia School of Law at George Mason University. He is a frequent contributor to the City Journal and National Affairs and writes in a number of publications. In addition, I'll mention that Adam hails from a great state in the Midwest, which George Will once referred to as wondrously immune from the pathologies and ignoble tendencies of American life. Of course, I speak of the state of Iowa. Adam White, welcome to the program.
Oh, it's always a pleasure to be here, Richard, but especially with an introduction like that.
Well, in Iowa, as I'm sure I know, and I forget which magazine did this, ranked it as the most best state to live in America.
That's right. That was, I think, U.S. News. And as it happens, I grew up in the part of Iowa that brought us the movie Field of Dreams. So it literally is the best part of the best state.
Well, okay. So Iowa has built it, and now people are coming.
Exactly.
So, yeah, I read a story recently of this woman. She was tapped out in California, but she took all of her assets. She was like 60 years old, and she moved to like Davenport, Iowa. And
That's another good city.
And she was able to make a life for herself. Moving from California to Iowa. Okay, so on that question, so not on Iowa, but thinking about the administrative state, before we talk about how it's fared under Trump and if a lot of promises and claims have been fulfilled or partially fulfilled, for our listening audience, we say administrative state, regulatory state, federal bureaucrats doing their work. What is the administrative state, and what are the challenges it presents to limited government?
Well, it means a lot of things to different people and in different contexts. I was in a discussion today with somebody who was referring to the administrative state in sort of the way that Francis Fukuyama uses it in his last couple of books, talking about the state, meaning the administrative apparatus that a modern state builds separate from the legislature to implement laws. So that's one way of looking at it. I think the best way to describe it is the way I've learned, or I'm borrowing from Matt Spalding of Hillsdale. He likes to say that the administrative state is not just the sort of the sum total of the agencies, and although that is true, that is one aspect of the administrative state, but also we often use the term administrative state to summarize a basic approach to governance, a state that is first and foremost administrative, one in which the main work of government on a day-to-day basis, not just in enforcing the laws, but also effectively in adjudicating them, and in the work of effectively legislating our laws, all comes out of the administrative agencies. And so it is a government which finds its center of gravity in the administrative apparatus. I think that's a good way to use the term, and I think unfortunately it too often describes the work of our government today at the federal level.
So let me ask you this question. A number of significant legal academy voices, Gary Lawson is one, Philip Hamburger another, would take the position that the administrative state as it stands is incompatible with our Constitution, with constitutional law. Do you see that? Do you see it as unconstitutional? And we've just sort of, but now we've got this thing, we've got to make it work, or do you see it as just sort of more, it's in tension with basic goals of our constitutional system, but it's not exactly unlawful?
It depends on what we mean by unlawful and unconstitutional. I don't want to sound Clintonian, but I'd say that
the basic position of you've delegated this power and you now have agencies making their laws, enforcing their laws, determining their own jurisdictions, all of that seeming to happen without that separation of powers, be it you can't be a judge in your own cause type thinking of our Constitution.
I'd say when people offer straightforward or simple arguments as to why administrative agencies are categorically unconstitutional, or that delegations of power from Congress to the agencies, effectively delegations of regulatory power, that those are unconstitutional and need to be nullified, I'd say I tend to be skeptical as a matter of principle and as a matter of prudence.
Okay.
We've had agencies in a way since the very beginning of our government, right? The Constitution expressly refers to departments. It doesn't define what they are or what they're going to do, but it does provide, or does assume that there will be departments that report to the president and that have leaders that are so significant that they require not just presidential appointment, but presidential appointment with the advice and consent of the Senate. There's a wonderful no, it's not new anymore, but a recent book by Fergus Bordwich called The First Congress. And it's a fascinating story, because what happens after the first Congress arrives and the electoral votes are counted and the president is sworn into office, what happens next? Well, first they impose some taxes, but then second, the Congress has to build a government. And they did it by creating the first departments, the Department of, well, today we'd say the Department of State, Treasury, and Defense, those departments, as well as the Office of the Attorney General. So the very first thing that Congress had to do, or saw that was necessary to be done, was to create some sort of administrative apparatus, of course, far different from what we have today. And then it had to vest the president and the departments with significant power. And that began a story that continues to this day. Now, there's obviously some major turning points in that story, whether it's the creation of the Patent Board or the Steamboat Regulatory Board in, I think, 1852, and then the Interstate Commerce Commission in 1887. And then you have the progressive agencies, first at the state level and then at the federal level, and then the New Deal, and then the Great Society, and on and on. It's a story with significant turning points, but it all begins in the same place. And it's hard for me to imagine a government today without cabinet departments exercising significant powers that often seem in substance to be somewhat legislative or somewhat judicial. I think that's unavoidable. But the question is,
I mean, I guess that's something that I've thought is bureaucracy is unavoidable. In any organization, even the most libertarian state, would develop a bureaucracy. What I hear you saying when we think about significant turning points is certain stress laid upon those agencies, certain power given to them, where we start to see tremendous opportunities for abuses of power that really cannot be checked in real time.
Right. I think that over and over again we find ourselves asking the same four basic questions. How do we structure an agency? What powers do we give it? What procedures should it go through as it's exercising those powers? And then how is its work, ex post facto overseen by the courts and also by Congress and by the White House? And so I think it's the same question over the same questions in different ways. And I think that even though, like I said, all this traces back to the first Congress, and oftentimes I shy away from the idea that things should just be categorically nullified as unconstitutional, I think it is fair to say that the way our government goes about its work, especially through the administrative agencies, is in tension with the basic principles of the original Constitution. I'd say when Madison wrote famously in Federalist 10 that we behold a remedy for the ills most incident to Republican government, it wasn't a bureaucratic remedy, it wasn't a regulatory remedy, it wasn't even a judicial remedy, it was a Republican remedy. And it's hard for me to say that the remedies that are proposed today for the excesses of Republican government, which tend to be in either the courts or in the agencies or both, it's hard for me to say that the balance that we have today or the proponents of agencies and the courts want to achieve are really Republican in a Madisonian way.
So that sort of brings me to the administrative state under Trump. And, Trump, as we all know, there's this idea he's going to throw out 2 regulations, or is it 3 regulations for every one he implements. Your assessment thus far, what's he been able to do? I'll say positively, because I'm ultimately a fan, generally speaking, of throwing out regulations. What's he been able to do with regards to the administrative state?
Well, the administration got off to a very good start. That's true. I mean, it's so hard to tell what's been accomplished so far because we're so early in the game. I'd say to declare victory on any reforms right now would be spiking the ball on the 10-yard line. And I don't mean the last 10-yard line. I mean the first 10-yard line. There's so much that needs to be done. We've just, we're now reaching a point where some things will wrap up at the agencies, the process, whether it's rulemaking or adjudication, and things will start to go to the courts for judicial review. And the next 2.5 years, the tenor of the next 2.5 years of regulatory reform could be very different from the first year and a half. So it's too soon to draw too many conclusions, but it's not too soon to say that the administration got off to a very energetic start in a number of ways.
Picking off, I take it a lot of the Obama regulations that were sort of just big and lumpy and out there, and they were able to, because they were enacted not through a notice and comment, which is something else we could get into. Not a lot of the Obama regulations were not enacted according to the standard procedure, but were just sort of informal. They were able to easily retract a lot of those if they wanted to.
Right. There were a number of so-called guidance documents and other things that were pulled down. It was interesting. You had people who in the last administration were asserting that President Obama was well within his rights to have his administration declare a new national policy of broad immigration non-enforcement to effectively waive those laws categorically for millions of people. In the Obama administration, a lot of people said President Obama could do that without notice and comment rulemaking. But now, as President Trump and his agencies try to unilaterally undo those pronouncements, you have a lot of the same people saying, oh, no. To undo these things, you have to go through a much more rigorous process because now people's rights are at stake. It's really, I think, a cynical argument. We'll see how it plays out in court. But you're right. There's a lot of things that the agencies have tried to unilaterally undo quickly. There's a lot of things that the agencies have begun notice and comment rulemaking processes for. For example, the EPA's Clean Power Plan, the big, really unprecedented assertion of federal power by the EPA over energy markets and energy consumption. That is in the process of a notice and comment rulemaking, and like I said, we could talk about that in a little bit. But I do want to say, of all the things that the Trump administration
so that
did
would
at
be
the
on that Clean Power Plan, because a lot of people talked about that.
Yes.
But that really, for that to be fully or de-implemented or taken off the shelf, that really depends on Trump winning a second term, I would think. It's that long-term of a project. Or am I wrong?
Yeah, I think that's a pretty reasonable prediction. I think the process for getting it through the courts is going to take at least that long, and it might take a couple of iterations. It might go through once, and the courts might disallow parts of the reform, and then the agency would need to try again. We'll see. But I will say, in addition to all those things, one of the real interesting things about this administration was its use of executive orders at the outset. The outset, the first days and weeks. Obviously, there are things that, a president can use executive orders for a lot of things. He can't use executive orders to violate or avoid the Constitution. He can't use executive orders to violate or avoid statutes, or at least statutes that are constitutional. But for statutes that vest agencies with really broad discretion, I think it was interesting and important to see the president issuing executive orders, really pointing his agencies in certain directions within the limits of the statutes. The classic examples of this would be the president's early executive orders on energy and the environment, and on financial regulation, and on a few other areas where he didn't dictate an outcome, but told the agencies that within the discretion afforded to them by Congress, they should have certain priorities. I think that's great, actually, because presidents have long had significant influence over agency outcomes. Elena Kagan wrote a famous law review article on this called Presidential Administration. I think it's good to see the president literally signing his name to these policies so that accountability really does go all the way up to the top.
With a hat tip to Justice Kagan?
Yes, it was my dean for a year in law school.
So that builds on Chevron then, and that builds on.
Yes.
And this would, and I take it the way you're discussing executive orders, this would have been a reason why, say, Justice Scalia in the 1980s and others were so supportive of the administrative state, that you really wanted to give them that sort of full authority to do sort of deregulatory work in an age of Republican presidents.
That's right. Doctrines like Chevron deference and a few other legal doctrines in administrative law, they really reflect two values that are often in tension with one another, not always, but a value of expertise and a value of democratic accountability. And on Chevron deference, the courts, they justify this rule in saying that agencies are more democratically accountable than courts. namely through the president, because we have a presidential election every 4 years, and in cases where a question of legal interpretation is really a question of policy judgment, better to have the agency make that judgment in the first instance rather than courts, because agencies are accountable through the president. So much of modern administrative law reflects the basic premise that agencies are legitimate not just because of their expertise, but because of their accountability. And I think that's right, and I think it was good then that the presidents did this. I wrote an article for the Notre Dame Law Review, it just came out recently, sort of spelling this out, and I pointed out that the real seminal use of this was actually by President Obama early in his administration on a policy I profoundly disagree with him on, namely embryonic stem cell research. He issued an order directing his agencies to increase stem cell research funding. And the courts, not only did they defer to the policy, they said that the agencies were bound in that case to obey the executive order. The agencies couldn't have ignored it if they wanted to. And I was involved in that case in a small way. I didn't like the policy. I didn't like the outcome of the case. But I thought the court's reasoning on that one point, in hindsight, made a lot of sense. So that's one innovation that I've appreciated seeing the Trump administration continue. But again, we'll see what that process actually results in. The executive orders are the beginning of a process, not the end of a process. And I think sometimes the administration's proponents, at least some of them, forget the difference.
Talk about we talk about this a lot, and this sort of fell on deaf ears, particularly. I remember the last 2 years of the Obama administration got really innovative with the use of executive power, and right. The refrain was, don't use a power you wouldn't want to see your opponents use for their own ends. What has the Trump administration, in your estimation, learned from Obama, how Obama creatively used executive power?
Yeah, President Obama liked to boast famously or infamously that he had a pen and he had a phone and he was going to use it when Congress wouldn't act. Well, sometimes it seemed like he or his proponents forgot that the pen and phone stays in the Oval Office. They don't go home with Obama when he finishes up his second term.
They don't go to the Obama library.
That's right.
Should it be built? Right. Okay.
Although it would be kind of great if the Obama library literally did have a pen and phone exhibit. That would be. So I would make a donation to the Obama library for that exhibit.
Too. That's a good point. Yeah.
So some of the things, again, it's too soon to tell, and the Obama administration got innovative near the end, because that's when there's really the administration, any administration sees that there really isn't any alternative, right? You don't have much time. You're not going to get any legislation through. That's why Obama spent years saying he couldn't unilaterally change immigration law that would require that the things that his party and activists in his party were demanding would require legislation. He said that for years, and then finally changed his mind and said, okay, we'll do it unilaterally through non-enforcement. And he actually said in one speech, I changed the law. And I think it'll be interesting to see near the end of President Trump's time in office, whether it's one term or two, how these things change. We're already seeing little bits of it, right? We've seen, like I said, President Trump make energetic use of executive orders on policy questions. We have seen the administration using some of the same tools for taking down the policies that the last administration put up. But one thing that's interesting, and we saw this just in the news recently, was a decision by the Justice Department not to enforce or defend in court a provision of the Affordable Care Act. Now, this just happened very recently, and I haven't gotten to study the issue, so I don't really know the merits of it, whether the Justice Department's right or wrong. But it was interesting to watch the debates flare up on Twitter in the immediate aftermath of the Justice Department's filing. Critics of the administration complaining that the Justice Department has a duty to defend laws in court, when every critic of the Obama administration could immediately point out that this is exactly what the kind of thing that the administration did with the Defense of Marriage Act, where they famously or infamously refused to defend its constitutionality. And of course, there's other examples, right? DOMA is the obvious one, but in the Zivotofsky case, where the Obama administration refused to obey a statute regarding passports and the designation of Jerusalem as being the capital of Israel. the Obama administration refused to honor or defend the statute, it's interesting to watch Trump's critics make these arguments without really thinking seriously about the precedents on this, at least the political precedents. My favorite example, just one last one. Think of the first big controversy in the Trump Justice Department. The very first controversy was the acting Attorney General, Sally Yates, whom Trump had inherited from the Obama administration. She refused to defend in court, or she announced that she would refuse to defend in court President Trump's initial executive order on immigration policy and entry into the U.S., and she won plaudits for this. She may well be the next Democratic Attorney General because she said she would not defend the law in court. And her statement when she announced this, it was stunning, and it bears directly on this new debate over the ACA. She said in her letter, she said that while the Justice Department's line attorneys are charged with advancing reasonable arguments to support an executive order, her role as the leader of the institution, she said, is different or broader. She said, now I'm quoting, "My responsibility is to ensure that the position of the Department of Justice is not only legally defensible, but is informed by our best view of what the law is." And then she said, "We also need to ensure that the positions we take in court are consistent with our solemn obligation to always seek justice and stand for what is right." She said she needed to decide whether an executive order was, as she said, it is wise or just before allowing the Justice Department to defend it in court.
So not a lawful inquiry.
No, not just a lawful inquiry, right? I guess she really took the term Justice Department literally.
Yeah. What would Justice Kagan think about that reason?
I don't know, actually. She was
thinking
Solicitor
about
General.
Think about the law review article we just referenced. Because
it's hard to say, because the president's interests and his responsibilities go beyond not just defending laws in court, but it carries with it broader obligations of constitutionality, of prudence, and so on, and to not only take care of the laws are faithfully executed, but also to faithfully execute his office. And so if the Attorney General is just for these purposes the alter ego of the president, then maybe this sort of broad, holistic approach is justifiable. I think it probably is justifiable. But what's interesting is just barely more than a year after watching Sally Yates become a national hero as Attorney General for staking out this broad position, you now have the people who cheered her on the loudest condemning the Jeff Sessions Justice Department. And like I said, Sally Yates will probably be Attorney General someday precisely because of the position she staked out.
Thinking about administrative state reform under the Trump administration. So fair to say, just a broad characterization, and I forget, I've read different op-eds where the notation of the dollar impact of the retracted regulations, and it's quite sizable. Other people have talked about sort of a psychic impact on business of knowing that there's a president sort of on their side, and it's sort of helped unlock some animal spirits. But along those lines, if there's going to be real reform, it can't just be at the executive level. It's got to be a congressional statute or some sort of structural regulatory reform.
I think that's right. I think the current administrative state reflects, the legacy of choices by all three branches of government, by the president, by Congress, and by the courts. And I think meaningful reform requires the efforts of all three. We've seen, like I said, the Trump administration, moving forward with executive orders, the subject matter specific ones, and also these across the board ones you mentioned, like the two out, one in standard, and putting a regulatory budget on the agencies. Mm-hmm. But there's some good proposals in Congress that have passed the House over and over again long before this administration, but which dead end in the Senate, which is as we all know, blocked by the filibuster. One is called the REINS Act, which would prohibit across the board agencies from imposing the costliest regulations without first getting approval from Congress and the president. Effectively, it would undelegate power from the agencies to make the costliest rules. And instead of imposing these things as regulations, the agencies would in effect be teeing up legislative proposals for Congress to vote on. I think that's a good reform. I think it's probably, even though it hasn't passed and it may never pass, it's easier to imagine the REINS Act passing than it is to imagine Congress amending every broad delegation of power that it's ever legislated before. So I think the REINS Act is worthwhile. One that doesn't get as much attention, but I think is at least as important, is called the Regulatory Accountability Act. This would be the first really comprehensive modernizations and reforms of the Administrative Procedure Act since the APA was enacted in 1946. It would make the rulemaking process more iterative. There would be more rounds of notice and comment. There would be more opportunity for in-person confrontation of the agency through hearings. There'd be substantive standards of cost-benefit analysis that would be imposed by Congress, and then also there'd be more judicial review of that cost-benefit analysis. I think that's a very strong proposal. A version of it, it's passed the House. A version of it was introduced in the Senate with bipartisan support. It was Senators Portman and Hatch on the Republican side, and Senators Heitkamp and Manchin on the Democratic side. But it's going nowhere in the Senate due to the filibuster. And I would add that the administration itself hasn't done a whole lot, as far as I can tell, to put its shoulder behind these proposals, and that's a great disappointment. And I think
that would be, that's sort of consistent with Trump's. Seems to me he doesn't see the institution of the presidency or the executive branch as something he's long-term thinking about in terms of its precedents and norms. It's more of a platform for himself.
I think that's right.
I wouldn't see him engaging, and that's sort of my thought. But I don't watch it as closely as you do.
Well, it's not just the president, though. I'd say there's, so much of it. Modern administrative law was shaped by the Justice Department, and what a whole line of attorneys general during the New Deal era, the reports that they wrote, they are still cited today as authoritative. Even if the Justice Department isn't going to push for legislative reform, it would be good for the Justice Department to do more to diagnose in official reports and studies the current problems of administration, to help create a record for future legislative efforts.
On the question, we would be remiss if we didn't just briefly mention the Congressional Review Act.
Yeah.
And the way that this legislation, which I think was never used that much, in the first year of the Trump administration, used, a dozen times maybe, to repeal Obama regs within the last 60 calendar days of the administration. And then there's some talk, there's a belief that any of these sort of, informal regulations, there's no time limit on it. They could just sort of willy-nilly repeal those. That's been a boon in the Trump administration.
That's right. Let me just spell out how the CRA works for listeners who don't follow it. The Congressional Review Act, which was enacted in the mid-1990s and signed by President Clinton, it gives Congress the opportunity to vote up or down on agency regulations. Agencies are required to report to Congress their regulations, which includes guidance documents that don't go through notice and comment.
Okay.
And when Congress receives that report, then Congress has a very limited window. I think it's 60 legislative days to vote down the regulation. And if both houses of Congress vote to block the regulation and the president signs that joint resolution, then the regulation is null and void and actually can never be repromulgated by the agency without new authorization from Congress. It's an extremely potent tool, but the way I just sort of framed it up hopefully makes clear what the problem is. It requires the president's signature, and it's hard to imagine a president signing to block a regulation that came out of his agencies, including, going through the whole White House oversight process for the regulation in the first place. It's hard to imagine a president signing to block his own regulation. And so these things really, the only time it was ever going to be used was during a presidential transition, where the final work of one president's agencies then can be reviewed for 60 legislative days by the new by Congress and the new president. So after 20 years on the books, it was only used once. It was used once in the first days of the George W. Bush administration, and then never again until this administration, which voted down I think 14 or 15 of the Obama era rules, and one new one from the CFPB, which is a controversial independent agency that was not really aligned with President Trump on policy at first, and so they've used it in really unprecedented volume of rules. But you alluded to one other thing that's really important. There's an opportunity for this administration to go back and use the CRA to nullify rules and guidance documents that were never reported to Congress in the first place. And it turns out the agencies for years upon years, well before the Obama administration, were being negligent in actually reporting their work to Congress as required. And the 60-day clock doesn't start until something's been reported to Congress. And so on the face of the law, and I do think this is the best reading of it, it empowers the agencies today to belatedly report their rules, their regulations and guidance documents, and start a new 60-day clock for Congress to vote. And again, if Congress votes to block one of these long-standing rules, then it's blocked. The agency is blocked from ever repromulgating it again. It'll be interesting to see if the agencies in Congress make use of this later this year or in future years in the Trump administration.
I suspect they will. I would think, although I guess they're down to one vote in the Senate. Maybe the difficulties there of leveraging that vote. I don't know.
Well, and also the scarcest resource on Capitol Hill is floor time, and the Senate is focused first and foremost on confirming appointments, especially judicial appointments, and so that just might become the Senate's top priority atop the CRA.
Question, just thinking about another hot button informal, was the Education or the Office for Civil Rights Dear Colleague letter that lowered, if you were accused basically of sexual assault on a college campus, you could be found guilty on preponderance of the evidence, tried by some sort of, student judicial court or whatever university implements there, and be found guilty and basically your life ruined. And that was, communicated to colleges and universities receiving federal aid. And if they didn't implement this system broadly, then they could lose their federal money. Where is that?
Well, it's funny you mentioned that we had an event.
I've been told it was lessened but not repealed. I don't know.
I thought that the Education Secretary, Betsy DeVos, had begun the process of taking down that policy. It's funny you mentioned it. We had an event, the day that we're taping.
Too, it's not even removing it, though, because these universities have already implemented a system. You've got to actually reach into what they've already done and incentivize them to undo it, I would think.
Yeah, that's right. We had a fascinating conversation on precisely that topic on today, the day that we're taping this conversation. Here at the Hoover Institution, we had Shep Melnick from Boston College to do a book event. I think Shep. I think has Shep been on this?
Yeah, on this question. Yeah,
that's right.
Civil Rights
Shep came to
agency overall and how they function. Yeah.
That's right. Shep has a new book out called The Transformation of Title IX, Regulating Gender Equality in Education. And one of the points that we touched on was, as he refers to it, the civil rights state. So the collection of agencies and the courts and the private parties who all play a role in creating and implementing these gender policies. One important aspect of it is the way in which the institutions themselves, the schools that are being regulated, with the backdrop of the threat of losing their funding, the way that they have institutionalized these things, that they have created bureaucracies within their own bureaucracy to continue to implement these policies. And the change of administrations from Obama to Trump to whoever comes next probably doesn't make as much of a difference as people might think, because these new institutions, these new bureaucracies in the schools themselves have their own interests, their own sort of self-conceived mission, and a lot of power to keep doing what they want to do, especially when they know that someday there will again be a Democratic presidential administration that will move as swiftly as possible to restore the policies that the last Democratic administration put into place.
On this question, also, we think so. These informal guidance documents, and this sort of just brings to my mind. You think about all of the ways the administrative state affects our lives, and this sort of gets back to where we started, and thinking about separation of powers. Where's Congress in all this? Why? I know this is a big question. We could probably talk about it for an hour. Why are
Sure.
they? Why do they seem apathetic? Isn't the word, but unwilling to challenge or engage constitutionally the workings of the administrative state. The only time we hear about them engaging is when there's a controversy and they want
Yeah.
to hold hearings and try and embarrass someone. And even then, if you really think about the IRS, this is well known. Nothing really seemed to happen to the IRS, but apart from a fine for what they did to all the Tea Party groups. So that's just my question on a lot of people's mind. Why does Congress stink?
Well, you like you said, we could discuss this for a long time. Let me try to touch on that.
Put it differently in the words of Publius. Why do they not have ambition for their office?
Yeah, well, that's exactly right. Congress is, in the Constitution, it is literally the first branch of government. But today, it seems mostly content to just be an ombudsman for the administrative state, and to wait for an opportunity to criticize what a particular agency does, but with less movement towards actually reforming things and actually legislating. And I think you're exactly right. The question is a lack of ambition, as Madison used the words. Now, again, I always try to go back to the beginning and say we shouldn't over-idealize the past, right? The president, by the nature of his office, through his energy, always has an advantage of a sort. Hamilton mentions this in his debates with Madison, right? The Pacificus Helveticus debates, where Madison said, or Hamilton says, that the president has effectively the power to create an antecedent state of things, right? The president can take action and create sort of the new status quo that Congress and everybody else then has to operate from. And so this today we call it a first mover advantage. This has always been an advantage of the presidency, even more so when the president is exercising or he's administering statutes that are written so broadly by Congress over a century to effectively give the president power to do almost anything he'd want to do, or at least to make a credible effort to invoke a statute. So Congress is in response mode all the time. But the question is, why do they seem so content to do that? My predecessor at the center that I run at Mason, Professor Naomi Rao, who's now in the Trump administration at the White House, she's the administrator for the Office of Information and Regulatory Affairs, which is a long way of saying the sort of the chief regulatory overseer at the White House. She wrote a really interesting law review article a few years ago on some of the institutional reasons why members of Congress are content with the current arrangement, whether it's members of Congress, can individually badger agencies and take credit for it, or members of Congress become committee chairs who like sort of having the power to convene hearings and ridicule agency personnel, but without really doing anything. But when we think about ambition and the way that Madison used it in the Federalist, I think it's important to keep in mind his other line, right, that the interests of the man must be attached to the rights of the place. It's not that members of Congress aren't ambitious. Right. Obviously, they are. They're ambitious to get on Fox News and Morning Joe and act like an outsider and criticize Congress.
The administrative state.
Right, and also criticize Congress for not doing enough about the administrative state. But they're not. They don't have the same interest in being ambitious as a part of Congress. And I think the reasons for that are too many to mention, and they range from the creation of modern political parties to modern communications and so on. But there's one last thing I think we need to keep in mind, right? It's that Congress can serve as a well-functioning legislature when it has the incentives to do so. Today, I don't think it does, and I think it's this question of gridlock. Oftentimes, proponents of the administrative state talk about gridlock, and they say the gridlocked Congress effectively justifies the administrative state. Congress doesn't act, so the agencies will or the agencies must. But I think the relationship works in the other direction as well. The fact that you have these agencies out there that can do almost anything that they want to do really changes the incentives and the hydraulic forces in and around Congress. Let me give you an example. At the outset of the Obama administration, one of the administration's priorities was climate regulation. And President Obama told Congress, give me a bill, or if you don't, I will act unilaterally through the EPA. Well, and he's talking to a Democratic Congress in both houses. He had total control of the government. Now, of course, there's the filibuster and so on, so I don't want to minimize that. But let's think about how this works. When the president says, legislate on this or I will act, well, when that happens, why would the president's party in Congress make any compromises? Why would they offer any compromises when they know that the EPA can deliver them a whole loaf instead of a half a loaf? And by the same token, why would the other party in Congress volunteer any compromises, knowing that the president's party has no real incentive to compromise? I think that the administrative state itself...
So what you're saying is an undermining of Republican government.
That's right. I say that it has its own gravitational pull on our legislative process. I think it deforms our legislative process.
Well, what's interesting there, too, is, to think about that climate change bill that Barack Obama wanted in 2009. He couldn't get it. I mean, he had lopsided majorities. He couldn't get it from his own party.
Exactly.
I mean, his own, he had so many senators from various states that would have come out net losers. So, I mean, really, we're seeing... It's like a cookie cutter case almost. Thinking about, I want to just try and switch here at the end and
sure.
Thinking about reforming the administrative state. Now, your colleague, a little bit more, your colleague at George Mason Scalia School of Law, Michael Grava, has said on Law and Liberty a number of times that the way we think about it is wrong. And so we're going about this all the wrong way. And we talk a lot of eliminating Chevron deference. Is one that we constantly hear about. You've talked about the REINS Act. And Grava would say the administrative state is too big for judges to ever really police it effectively using judicial review categories. However we might augment those cost-benefit and reviewing cost-benefit analysis could never really do it or impede momentum of the administrative state. And likewise, the REINS Act or anything where you would sort of give Congress an opportunity to veto things that they cost too much wouldn't probably work either that much. Just
right.
Would be a marginal. And so Grava wants to propose a full-scale administrative court system. Now, this is obviously a reach practically, but you would have it would be independent from the agencies it reviews, non-specialists, so they wouldn't be tied to the agencies. You couldn't overturn except for a constitutional question. And the agencies, if they lose, they pay costs. And so just sort of thinking, isn't it time really to get kind of more, not just more radical? I don't think he's not talking about overturning the administrative state, but I think making it regular and more formal and more accountable to the people it actually regulates. And so I'm curious to see or hear your thoughts on that proposal or something along the lines similar to it, as opposed to the way we talk about it.
Well, so it's interesting. There's a debate right now, and the Supreme Court is going to issue a decision on this any day, probably, about what we call administrative law judges. They are, or ALJs. They are officers within an agency that are sort of like they're sort of like judges. They call themselves judges. They have a little bit of insulation or independence from the rest of the agency, but they operate within the agency, adjudicating disputes before they're finalized at the agency and go up to the real courts. And so the question is, what's their proper place in our constitutional system? The case the Supreme Court's about to decide, it points out, the challengers pointed out that the Constitution requires that officers be appointed only by the president with advice and consent of the Senate, or there's other ways too for inferior officers, but there's a certain way for these people to be appointed, and the ALJs aren't appointed that way. And in the context of that debate, you have proponents of the ALJs saying that we must not subject ALJs to the political pressures of the ordinary agency structure, that they need to be made independent. And the response to that is, well, we have in our constitutional system a structure of independent judges who are insulated from political pressure. They're called judges, and they're appointed in a very specific way, and they are protected in very specific ways. And maybe the answer is to take ALJs and make them into judges, into real judges. But then at the same time, you see the same people sort of recoil from that suggestion. It's not clear to me why. Now, on Michael Grava's suggestion, and I'm a fan and a lifelong student of Michael, and I respect him a lot. I'd have to think through this because I haven't thought about this specific proposal. And I don't know if what he's proposing is just the creation of a new court with a lot of judges who do nothing but review agency work. On the one hand, that could be a great idea. On the other hand, it's not hard to imagine if you create a new subset of judges who are different, who are sort of set aside from the rest of the judges, how this might take on a very different very different character. Imagine if someday, and I think the real power would be in which president actually gets to appoint these initial judges. Imagine if this proposal were taken up by future President Kirsten Gillibrand, right? And that she was the one who was able to get this legislative proposal through and create it, and then pick this entire stock of judges, and then have them sit in judgment of not just her agencies, but future ones. I'm just not sure what I make of that. But one last thing about this. I like Michael's instinct that the solution here is not to tear down existing agencies, but rather to build up new institutions. I think that's exactly right. I think that Steve Bannon won a lot of headlines in the first month of the administration when he said that they wanted to deconstruct the administrative state. I think that's really misguided, and I think history tells us, experience tells us that just won't happen. What we need to do is reconstruct something other than an administrative state. We need to reconstruct an unadministrative state with institutions that check and balance the agencies in the ways that they need to be checked and balanced.
Adam, on that note, I think that's a good note to end, and appreciate your time talking to us about the administrative state under Trump, and I guess we morphed into opportunities, prospects for reform. Thank you so much for your time.
Thank you, Richard.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.